secrets. And let me see if we...
Yeah, we can go ahead and pull this up.
Yeah, let's go ahead and get it. It is, see, yeah, that one right there.
Which one?
The CSUB 917. Hopefully it's going to read.
Seems like it should.
Yeah. Well, we'll wait for that to pull up.
There you go.
Oh, good. Okay. Great. How do I just...
Yeah, if you want to just use the
okay.
the down and up arrows.
Great. Okay. Anybody dealt with lawyers before? Probably a good thing that you haven't. Let me tell you a little bit about what a patent attorney does. In Bakersfield, I don't know how many, there are hundreds of lawyers in Bakersfield. To my knowledge, there are 3 patent attorneys. That ought to tell you something. That patent attorneys are not as frequently encountered in the legal profession as most other areas of practice. And there's one large reason for that. And that's in order to be a patent attorney, you have to have a technical undergraduate degree. Mine happens to be in petroleum engineering, so Bakersfield's an appropriate place to be. And you have to take a separate bar examination for the patent. You've heard about the California bar exam. It's pretty grueling. The patent bar is really grueling too. So it's difficult to get there. I'm very happy that I've gone through that because there are just a limited number of patent attorneys, and we get, within Bakersfield, I get more work than I can handle, to tell you the truth. So it's a really interesting area of practice. I pretty much just represent inventors or businesses that are trying to protect their intellectual property. I do not sue people very often. I used to do that. I'm happy that I don't do that much anymore. It's a much more congenial relationship you have with people when you're trying to do something positive, which is go out and protect their intellectual property, help them fulfill a dream. You know, whether it's getting an invention patented, or getting a trademark registered, or getting a copyright registered. It's just inevitably it's somebody who's pursuing something that they want to do, and it's just something that they really want to have done. So with that said, this is showing you the 4 basic types of intellectual property protection. Trade secret is essentially anything that can be kept secret and that has value because it's kept secret. So you've heard of, the Colonel Sanders, secret ingredients of herbs and spices. It's trade secret. The formula for Coca-Cola, it's trade secret. It is not out there for anybody to get. It has to be kept as a trade secret. It has to be kept in confidence. So Pepsi-Cola can go out and they can buy all the Coca-Cola they want, and they can subject it to any kind of analysis they want to figure out how Coca-Cola makes it. Perfectly acceptable to do that. What they cannot do is go out and hire a chemist for Coca-Cola and get him to tell them what the formula for Coca-Cola is. And that would be misappropriation of trade secret. If they did that, they would be sued inevitably. And I think a couple of years ago there was a suit where the FBI actually arrested somebody who was trying to sell the formula for Coca-Cola. So in essence, anything that can be kept as trade secret, where it's very difficult to reverse engineer it, is good as a trade secret. Source code is really, can be held as a trade secret. Many times very difficult to get in and figure out exactly how a routine works. And so that's one area that is really treated as trade secret usually. The most common way you lose trade secret protection is you have employees, you bring them in and you train them to do a particular method, or you give them a recipe or a chemical formulation or something like that, and they know it, and then they get hired and they go out and spill it to somebody else. And again, that's going to be cause for a lawsuit. It happens quite frequently. When an employee leaves and they take trade secrets of one employer, and they give it to the new employer, there's typically a lawsuit filed. Okay. Next type of intellectual property protection is copyright. I will tell you that many lawyers that I run into have a difficult time knowing the difference between copyright and trademark. And the difference is this: a copyright is a right in an original work of authorship, and it's a painting, a song, a script, a work of visual art. Any one of those things can be protected under copyright. What it does is exactly what it says. It gives you the right to control the copying of that particular article. So if you take a beautiful photograph of the Grand Canyon and you register the copyright in there, then you own it and you can license the use of that image. And if someone goes and they copy that image, then you can go after them for copyright infringement. However, the difference is, if you take that photograph and you've got someone standing right next to you taking the exact same shot, same image, and then they go out and they sell it, they're not infringing because they made it themselves. So it protects original works of authorship, but not something that is independently created by someone else. Then we've got trademark or service mark. Trademarks, they identify a source of goods or services. I mean, you see them all the time. Coca-Cola, very powerful trademark. Ford, Chevrolet, all those are identifying a particular good or service. Then we've got, coming down there, but utility patents, and this is really the heavy-duty type of intellectual property protection. If you have a utility patent that is for a valuable good, or a valuable invention, a pharmaceutical invention, something like that, it can be very, very valuable. For pharmaceuticals, some of those patents are yielding billions of dollars to their owners. And that's why when you look at the price of some drugs, why they are so expensive is because so much R&D went into that, the time that it took to get the patent. And that's why they're very protective of the that's why the government is willing to grant that protection for those patents. And then finally, we've got design patents. Those protect the way something looks. So there's the classic Coke bottle. Anybody remember that? Well, the classic Coke bottle had kind of that classic look, I guess. And they they obtained a design patent in that, and that protects the way that bottle looks. But a design patent, the way you can get around it is it's really altering what that design is, and then you can get around it. Okay, so I'm going to talk a little bit about copyright. It is huge. It's probably more than I can really get into today, and I think it's kind of beyond really what the purpose of today is. But copyright, again, it protects, this is the things it protects. What really changed copyright law was the launching of the internet. I went to a seminar down at UCLA about 5-10 years ago. And some of the fathers of copyright law were there, and they were talking about it. They're saying in the early 60s, mid-60s, they pretty much viewed copyright law as a dying area of the law. He said there's just really not a whole lot that's going to make it exciting to them. And then they heard about this thing called the internet, or what became known as the internet. And all of a sudden, it just launched a whole new area of law. And so pretty much any time you go on the internet, and if you copy something, you have to be concerned about copyright infringement. So these are the types of things that it protects. Term of protection, it lasts a long time. It can last right now, it's 70 years following the author's death. And they've referred to this as the Walt Disney Protection Act or something like that, because Disney's been one of those that's been responsible for getting the term extended to protect things like Mickey Mouse and so on. Okay, this is just the remedies. When I refer to remedies, I'm saying that if you file a lawsuit, what are you entitled to get as a result of that lawsuit, okay? And so one of the things you can get is statutory damages per act of infringement of up to $150,000 per act of infringement. Where this really hits home, and I had this happen a few years back, it's kind of quieted down. Back when kids were doing illegal downloads, with various, search engines or downloading engines, and they're ripping things off, the record companies, they would trace them down, they'd find out, the internet address of those particular computers, and they would actually sue the people who own those computers for illegal downloads. They were really trying to send a message out there that, hey, we're going to police our copyrights, we're going to come after you, and so therefore don't do it. And so I would get parents come in and say their child had downloaded 20 songs, and so the record company or the publishing company comes after them and they say, okay, it's $150,000 per act of infringement. This is your exposure. And these people are coming in thinking they're going to lose everything they had because their child, illegally downloaded one CD. And so fortunately, we were usually able to make those things go away pretty quickly. For one reason, the copyright owners realized this was kind of a losing proposition for them. But they take it very seriously. And now they're finding other ways of generating profit centers from the music. I mean, and so much now, as you guys, more than anyone else, realize, so much of this stuff is available, but you're getting it through, like Apple Music or other forums like that where you can get it, you can subscribe to it. But the artists, I think, realized a long time ago that they were not making a whole lot of money on record sales anymore. And so they've really transformed the whole way they do business. A lot of them doing a lot more live performances or doing things like making YouTube videos and getting sponsors or endorsements on YouTube and that sort of thing. So it's really changed and revolutionized the way that business works. Okay, so for infringement, it's very simple. You have to have access to the work, and then you have to, it has to be substantially the same as the copied work. Now, so the way this works, so I have a client, local medical organization, and they went to a web designer, and they wanted a website for their practice. And so the web designer builds them a site, and they left it up to the web designer to come up with the art for that particular website. So the web designer goes out and finds various images that he puts on the website. And one of them is something like a really generic photograph of like a doctor with a stethoscope, right? I mean, you've seen that type of image all the time. And so they put it on the website. Well, it turns out that image was owned by Getty Images. And so Getty Images actually has web crawlers out there looking for their images. They found it, and then they sent a demand letter to my client saying, hey, you've got our image, and this is what it's going to cost you to settle this. And unfortunately, with copyright infringement, if they can prove it's their image and that you had access, it's strict liability. And in that particular case, and because my client actually had money, we settled for about $30,000 for using one downloaded photograph off of Getty Images. So I tell people all the time, if you're building websites, if you're hiring web designers, you want to make sure that you have clearance for the images that are going to be used on that website. It is just very dangerous to go out and just grab images off the internet and think, oh, they're there, I can use them. That's a truly incorrect statement. You have to have clearance on them. Okay, and this is one of my favorite cases, and I talk about it a lot. George Harrison, who you may or may not be familiar with, a former Beatle, deceased Beatle, wrote the song My Sweet Lord. Pretty large hit in what, the 60s or early 70s? One of those.
Early 70s, I think.
Yeah, pretty big hit. And he gets sued by this band, I think it was the Ronettes or the Shirelles, something like that. And they had a song called He's So Fine. And if you listen to the melodies, My Sweet Lord, on the chorus, it overlays He's So Fine almost perfectly. Okay. George Harrison gets sued for copyright infringement. And he testifies. He goes, I have no recollection of ever even hearing this song. So there's big trial, and the judge hears George Harrison's testimony, and he writes an opinion. He says, George Harrison, most believable witness I've ever heard. Very credible. I believe him that he does not recall ever hearing it. However, he testified that in the early 60s, he was working in the music business in Great Britain. There was evidence in the record that He's So Fine had reached within, I don't know, say the top 10 on the charts in Great Britain. And so the judge's conclusion was there's absolutely no way that George Harrison did not hear that song. Now, it might have been entirely subconsciously, but he put it in to My Sweet Lord, but it didn't matter. And because for copyright infringement, it just takes access, so they proved access, and it requires substantial similarity, and they had that. And then he later wrote a song about that whole experience, and he was a little bit jaded about the whole thing. Okay, the Blurred Lines case. Now, you guys familiar with that song? I am not.
I know it. It's a good song. Pharrell, Blurred Lines.
Okay. Okay. Well, he got sued. He and Robin Thicke got sued for copyright infringement by the estate of Marvin Gaye. And same thing, and they ended up winning because it was, substantially the same. Okay, Stairway to Heaven. You guys familiar with that song? Okay, and this was, I actually heard the attorneys who represented Led Zeppelin talk about this case. And it was really a fascinating case. The interesting thing, among others in the case, is this lawsuit is filed years and years after Stairway to Heaven was a big hit and made lots of money. And you have to kind of wonder, well, gee, why can they do that? And there is a statute of limitations on copyright infringement. Yes?
I have a question. So, any artist that copies the same beat as a previous song can be sued?
If it is substantially the same as what they've copied. And and there's a lot of cases on sampling, where I think the Pretty Woman case, if you're familiar with that, there was a huge amount of sampling that was done on that in that particular record. And in that particular case, it was not found to be infringing. So it's unfortunately, there's really no black and white on these cases. On Stairway to Heaven, this was a band that had played with Led Zeppelin early on, and a guy named Randy California. And the claim is that Led Zeppelin copied that acoustic instrumental that starts the song, said he took that from the song Taurus. And the jury ended up coming out saying, no, it's not the same. And one of the things they did, and what this attorney that I heard talk about, is they put in so much evidence that this particular configuration, particular melody, had been repeatedly used, for centuries. And so they were able to escape it that way. Okay, fair use, too complicated to get into here, but essentially what it means is that you can use small parts of things. Say you're writing something for a student newspaper, and you are going to critique something, you can pull out a certain amount of that work so you can critique it. It's not a sure thing, but ordinarily, if you're making money off of the copy, though, that generally is a pretty good indication that there's potential infringement. Okay, and these are just various factors for fair use. Okay, I've already mentioned about web design and why you want to be careful of that. By the way, works of the United States government, they are not protected. You're taxpayers or future taxpayers, you're entitled to use things that are works of the United States government. So, copying patents, free to do that. There's no copyright protection on those. Okay, these, when you were, getting things, downloading images or things, if there's a license associated with it, you want to make sure you read the license. Like in the medical practice case that I was telling you about, the guy had downloaded it and he had paid, I think, for just the private user license, so maybe he paid $5. He did not pay for the commercial use license, would have made a difference of several $100s, and that's why you have to have the correct license. Okay, this gets into linking and web design. And okay, music publishers, this is a whole other area of the law, which is, to me, is fascinating. I don't do that much of a practice in it, but if you're, you know, if you walk into a restaurant and they're playing music over the PA, there's potentially a claim that BMI, CSAC, or ASCAP can make for copyright infringement, because you're only allowed to use, you know, play over the radio or something like that in pretty limited groups of people. You know, if you have a bar that has just the broadcast television on, there's potential infringement involved with that. Okay, to trademarks. And this is much more of what I do. Probably 40 to 50% of my practice is in trademark law. And what it does is it gives you the right to exclude others from using trademarks or service marks which are confusingly similar to the mark, and to prevent people from tarnishing or diluting the trademark. And so if it's confusingly similar, what that means is if the average consumer of a particular product sees it and is likely to conclude that there's an affiliation between the product marked with this brand and the other product marked with this one, that's enough to create a likelihood of confusion sufficient to cause trademark infringement. Okay, the protection begins as soon as the use begins, which means there are what are called common law rights and trademarks. You know, people will say to me all the time, "Oh, did you trademark that?" Well, actually, for an intellectual property attorney, using trademark as a verb is like fingers on a chalkboard. There's what they're meaning is, did you register that? But as soon as you start using a trademark, you establish rights in that mark. Okay, so if you start a clothing line in Bakersfield and you start selling at Swaporama or something like that, and you've got this mark in it, even though you've not filed the application for registration, you've acquired rights by virtue of your usage. If you sell things online, and that's really increased the exposure for trademark infringement. If you're selling online and you have a website, even though you haven't registered, to the extent that you are selling product, you are creating trademark rights. Okay, again, this is where you protect it, file a lawsuit for trademark infringement. There are various things you have to prove in order to prove trademark infringement, and that's likelihood of confusion. And there's a variety of factors that go toward that, but it's how close are the marks, the strength of the mark, I'll get into that in a minute, the relatedness of the goods or services, and these other things that are here. Okay, so the advantages of trademark registration, and what I mean by trademark registration is you file an application with the United States Patent and Trademark Office for trademark rights in that particular name or logo. And when you do that, if you get the registration, and by the way, it takes about a year to get that trademark registration. If you get that, it gives you the opportunity for enhanced damages and also for the recovery of attorney's fees. So when if I have a client come to me and they've received a cease and desist letter saying, okay, you're infringing our client's trademark, makes a huge difference to me whether or not that cease and desist letter comes from someone who has a registered trademark. If it's a registered trademark, I take it extremely seriously. If it's not a registered trademark, then typically we can make it go away just by agreeing not to continue using the mark. Okay, you all seen the circle R? That means that it's a registered trademark. If you see that, that's something you want to stay away from. They're giving notice to the world that they're claiming rights as a registered trademark owner. And then you've also seen TM or SM. All that means is that somebody is claiming that they have trademark rights in it. And so I will tell people, if you started using it, if you start a brand and you want the world to know that you are claiming trademark rights, you can put TM next to it all you want. There's nothing wrong with that. So this is my firm name. We can use SM to use it so that we're claiming rights as a service mark. Okay, so I referred to earlier the strength of the trademark. What I mean by that is, okay, how frequently are you going to encounter that word? And how much significance has it taken on? The strongest trademarks are coined expressions. So Exxon, which is made at name, it has very strong protection. So, for example, if I opened an Exxon hamburger stand, chances are I'm going to get sued by Exxon because it is such a strong mark. People are going to see it and they're going to think that it's connected to the petroleum company. Okay? Kodak was made at name. Okay, then down that spectrum, the next thing is arbitrary usage. And that's where you take a common term, but you use it in a way that is totally unconnected with the way you're using it. So Camel for cigarettes, that's not as popular anymore. But, Shell for oil and gas products, that's totally arbitrary. Arm & Hammer for baking soda. Apple for computers, totally arbitrary usage. Then you have suggestive words. And again, as these are coming down, they're getting weaker and weaker, okay? So suggestive words, Ivory Snow, it's laundry detergent, good names, suggesting something that makes things look white and clean. Raid for insecticide, Pampers, Greyhound for bus, those are all pretty good. Then you get into descriptive. Those are things that are either geographically descriptive or they're descriptive of a particular quality of that product. Those are going to get less protection. And so, and many times they are hard to get from the trademark office. And then finally you have generic, which there's no protection for. And all these things I've listed here, aspirin, escalator, kerosene, thermos, all those things, those all used to be registered trademarks. And the reason they're not anymore is they became generic. And the way they became generic is that the owners of those trademarks allowed the trademark to be used to just be the actual name or identifier for the goods. Okay, so for like escalator, that you all have an image of what an escalator is, right? And so you're making a connection directly from that trademark or former trademark with the good. Aspirin, same way. You hear that name and you think of the item itself. And so you've got some trademarks. Kleenex is a great example. Xerox is another great example. Those came very close to becoming generic. And the way they almost became generic is when they started to be used to describe the good itself or being used as a verb. So if someone said, you know, did you Xerox that? That's a very dangerous use for a trademark. Or, you know, give me a Xerox or hand me Kleenex. That is, they really want to stay away from that. And so what they will do, and when you hear those advertised now for Kleenex, you'll hear them say, Kleenex brand facial tissue, right? Or you'll hear Xerox brand copiers. They will always tell you, okay, that's the brand name, this is what it is. And they're doing that for a very specific legal reason, and that's to keep it from becoming generic. Yeah.
What about Google in that respect?
You know,
Do you know anything about what they're pursuing? I mean, everybody says Google it.
Google is going big time after anybody who's trying to register anything. And I have not heard them come right out and say, Google brand search engine, whatever it is.
Sounds awkward.
Yeah, it does. But they are extremely diligent in pursuing anybody. In fact, I think one of the things I'm going to show you when we do a search is to show you one of the things that Google did.
Okay.
Okay, so the process of obtaining the trademark registration. File the application. It undertakes a substantive examination by a trademark examiner. When I say the word substantive examination, what that means is someone looks at it hard. They're not just looking at it to see, okay, are all the I's dotted and T's crossed. And that's something that I would call an administrative examination, where just someone's looking at it, okay, did you fill out the form correctly? With trademarks, that's not the case. They're actually examined by a trademark attorney. And what they will do is they will look at all of the existing registered trademarks and pending applications for trademark registration and determine whether or not, if they issued a registration for that mark, it would create any likelihood of confusion. Now, I didn't mention this earlier, one of the main purposes of trademark protection is it's a form of consumer protection. When you think about it, when you buy, say you buy a Hefty brand t-shirt, or you buy that because you know it has a particular thread count, you have a particular expectation of quality of the goods of that product. Or McDonald's. You go to a McDonald's, you know what quality you expect. It's why you go and buy Coca-Cola instead of generic cola and that sort of thing, because you have a particular level of expectation of what the product is going to be like. And that's why the government allows that protection. Okay. So when the examiners are examining these, they want to make sure that if they allow that registration, it's not going to cause confusion among consumers, among other consumers. Yeah.
What happens if you make like a logo or something and you don't realize that it's like, if you've never seen another logo before and you don't realize that it's like confusingly similar to it?
If you start branding the same product with a similar product and you start selling that, if you get the attention of the trademark owner, they're going to come after you.
So what if it's not the same product? Like what if it's like?
I'm going to get to that, okay?
Okay.
Because that's a good question. Okay, so and when the examiners are looking at these, they are going to look at how it's used. They don't look at it in a vacuum. They will look at it and say, okay, what else is out there? How is this person using that trademark? Okay, so the examiner will either issue a rejection or they will approve the application for publication for opposition. So what happens if it's approved for publication for opposition, the application is published in something called the Official Gazette. And anybody who's interested in trademarks, and it's normally trademark attorneys are looking at it, if they see something that is confusingly similar to one of their clients' trademarks, they're going to file an opposition to the issuance of that registration. If no opposition is filed, the registration issues, and I didn't mention this before, there's actually two types of applications. There's an actual use application, meaning you're already using the mark in commerce, and then there's an intent to use application, which means you have a bona fide intent to use it, and you can file it, and then down the road, once it actually is allowed, you can get the registration issued. And then for the intent to use applications, a statement of use has to be filed after the notice of allowance issues. Okay, so these are the common grounds for refusal. It's confusingly similar to a registered mark. It's merely descriptive. Talked about that already. And then the third one is not a real, ordinarily that's a rejection that I can overcome pretty easily. They say the description of goods or services is incorrect. Most people who file on their own, most of the time the description is incorrect and it requires amendment. That's actually something that can be amended. Okay, so how do I do a search now?
If you click Escape,
Okay.
and then you want to open up a web browser,
Yeah, where is it?
it's down at the bottom, Firefox or Internet Explorer, whichever you prefer.
Yeah, this is what. Okay, so say you are interested in registering a trademark for a product or business, okay? Okay. The place that I will start ordinarily is uspto.gov. This is the Patent and Trademark Office website, okay? And so when you get to this, and we're going to look at the patent side in a little bit, but you can come here to trademarks. Click on trademarks, and you see a whole variety of things, and you close out the survey thing here. Okay, search trademark database. And I'm going to go to that, and I'm going to go to the search system. Okay, it gives me a variety of ways of doing searches on this thing. The search option I almost always do is the structured search. It's just very easy for me to use. Okay, so let's go to McDonald's, okay? And over here we can limit the fields. What I'm going to call is I'm interested in a non-structured word mark. And what that means is it doesn't matter what the punctuation is or anything like that, but it's looking for that particular mark as owned by anybody. And so I'm going to look at that. And then the other thing I'm going to do, I'm going to look at, okay, I'm interested in, okay, what does McDonald's itself have? And I'm going to search on, I have, if you look through these things, I have all sorts of choices here. I'm going to go on the owner. And what hopefully this is going to do, it's going to pull up every trademark that has the word McDonald's in it that is owned by McDonald's Corporation. And there you go. And you'll see that there's a variety of ones out there. Let's see, the 270 total records. And you'll see that they're probably, there might be one or two exceptions, but pretty much everything that's here is going to be a trademark that is owned by McDonald's Corporation. You'll see also in some places it says dead. What that means is they have not maintained the registration, because trademark registrations, after 6 years you have to file a continued statement of use, and then after you file that, every 10 years you have to renew it. And if you don't renew it, it goes abandoned, okay? Then you're going to see some here. See, there's two numbers here. One of those is the application number, the one in the left-hand column. The one in the next column over is the registration number. And that means that at one point it was a registered trademark. And then you've got other ones like this one right here, Casa Ronald McDonald. You'll see that that is one that is shown as dead, but it was never registered. And for one reason or another, that did not go to registration. And if I go to this link over here, TSDR, it should tell me what the problem was, what happened. Okay, and it says abandoned after publication because they filed an express abandonment. So they actually asked to have that one go abandoned, okay? So that's one way of searching it. Now, so then the other thing that I can find kind of interesting is you can come over here, and instead of using and, so keep in mind what I searched for here was McDonald's as a trademark with McDonald's as the owner. Now I can come over here to where I'm going to say, okay, McDonald's as a trademark, but not McDonald's as the owner. And this can be kind of interesting to see what you get. And if you go through here, you see there's still 38 references. And the importance of this is, and the question that you brought up earlier about how it's used, well, these people have registrations. In this particular one, they have it because it's an investment advisory service. So the trademark office determined that there was not a likelihood of confusion between this use of McDonald's and McDonald's for restaurant services or hamburgers or whatever. So let's do the one you just asked about. Let's look at Google, and we'll do, okay, non-punctual. Again, we're going to go with Google as the owner, not the owner, and see what we get. Okay, so you've got, again, these are trademarks with Google in them that are not owned by Google, okay? And so you've got a bunch of them with Googles, and those are older marks. And so we see google.com here. And so this is owned by someone else. This is owned by Trademark King. And so this is still a live application. And let's see what happened here. Okay, so I think it has not yet been examined. Okay, so, okay, it's been suspended. So that, and we could actually, you can come over here when you go into that page, you can actually come in and see why something is going on the way it is. Okay, so all these things here are links that can tell you what's going on in the application. Okay. And okay, this one here, this is, okay, all I really need to know I Googled. Okay, and that is for T-shirts. You know, so somebody filed for that. We can come over here and find out what's going on. Okay, so abandoned because the applicant failed to respond to an office action. What this means is that in all likelihood, the trademark examiner looked at it and said, no, that's too close to the Google trademark. We're not going to allow that. It would create a likelihood of confusion.
Did you click on number 25?
Which one is that? Google it. Okay, so, and let's see why this one, okay. Okay, this is interesting because the applicant filed an express abandonment. I can tell you why they filed an express abandonment. They got a letter from Google's lawyers. Okay, so that's something you see all the time. Any other trademarks anybody's interested in seeing, whether or not something is registered?
Jim, I wanted to ask a question here. So we've got various small businesses that the students are doing projects for.
Mm-hmm.
And I'm really trying to focus on teaching them skill sets that are going to be useful in being in small business management. So if a company has the name of their the name of their company or the name of a product that they wanted to trademark, what would be some useful searches for them to be able to do before they come to you, so they've sort of done their homework?
Okay, certainly going to USPTO and doing that search is a good one. I mean, going on and Googling it is a good idea. Just find out, okay, is somebody out there using this? And then the other thing is, how are they using it? So if they're using it totally unrelated, and so I'll go back to McDonald's, okay? McDonald's for fast food restaurants is an extremely powerful trademark. If I start a restaurant and I call it McDunkin's, chances are I'm going to get sued by McDonald's, just because that anything for restaurant services is McDonald's pretty much owns that brand, and by virtue of the fact that they've spent millions and millions of dollars on marketing. Okay. Now, on the other hand, if I go out and open a McDonald's transmission shop, they're not going to be able to come after me because it's totally unrelated to the products and services that they're providing under that mark. So just because you know a name is used for something doesn't necessarily mean you're not going to be able to register the trademark. But you have to look at what they're doing. And by the way, just because you're spelled differently, that does not help you escape. If it sounds the same, all it has to do is create a likelihood of confusion. So if it sounds the same, if it's phonetically the same, that's enough to create that likelihood of confusion. Okay, so I would search here. You've got so much available to you through the internet to find out what's out there. So it's really helpful to know your competition. How are they branding their products? And then find something, and you don't want to be near anything where it looks like you are going to be confused with someone else's brand. So that would be the big thing. And I do this pretty quickly. Now, the due diligence that's necessary when you're applying for trademark registration is, I was telling you about the process of how it works, right? Your published proposition. As soon as you file that application, you've broken radar, okay? You're out there for the world to see. There are people who data mine trademark applications, and they routinely do it, send off solicitations and things like that. And certainly various entities who are interested in protecting their marks, they're watching those too. So before you even file an application for registration, you want to know what's out there. So what I do first for a client is I look at, okay, what is actually registered and what is showing up in the USPTO database. Even if it shows up as dead, you cannot rely on that at all. Those people still might be using that trademark. Okay, I'll give you an example. Everybody familiar with Frosty King in town? Mm-hmm. Okay, I represent Frosty King. And some guy in Florida, maybe 5 years ago, decided he wanted to start a chain called Frosty King. And so he goes and he gets the federal registration for Frosty King. And then he makes the mistake of sending the cease and desist letter to my client. Well, my client's been using the name Frosty King since the 70s. And even though they had not filed for federal protection, they established rights by common law rights. And so this guy sends that cease and desist letter. We actually got their registration canceled with the trademark office because when you get that federal registration, what you're saying is, I'm entitled to use this mark across the United States. And so even though this guy was only in Florida, by filing that application, he was claiming the right to use it in California, in Bakersfield, and we were able to get it canceled. So what I will tell people, when you are looking at doing your due diligence, you ask yourself, okay, how much am I about to spend? Are you about to, order clothing or inventory of some product for $100,000? If you're about to spend that kind of money and you're going to brand it, you need to do really comprehensive due diligence to make sure it's available. Because the worst case scenario is you go ahead and launch, you've spent that money, and then you get a demand letter to cease and desist. There's nothing you can do. I mean, if you keep going, you're going to get sued. Now, if on the other hand, you're going to go ahead and just file the application, file an intent to use application, you're really not going to spend any appreciable money, then you can, at least at that point, your exposure is small enough that you really don't have to spend the money for more thorough due diligence. But, and what you want to find out is not just are there any registered trademarks, but is there anybody anywhere in the United States that is using that trademark? So when Amazon.com launched, and they needed to have, for Amazon, of course, have it clearance throughout the entire United States. Well, it turned out there was a bookstore in Minnesota called the Amazon Bookstore that they did not clear. And they came in, and as soon as Amazon went live, they got sued for trademark infringement by the Amazon Bookstore. And that suit got settled for a confidential amount, but I guarantee you the Amazon Bookstore did very well for themselves. So again, you have to have clearance. The way that you do the due diligence is, and it's not enough just to search USPTO records. You can go online, you can search the internet. I normally will hire a third-party search company that specializes in going out and getting clearance. They will look at business databases. They will look at databases for every state, and they will do their best to unturn everything they can that it shows that someone is using a trademark. And it's, especially when you're about to spend big money, it's just too valuable, and there's too much risk if you don't do that. And so the starting point is federally registered marks, but then you have to go on from there and determine out, okay, what is your exposure if you keep going? Yeah.
So in the Amazon example,
Mm-hmm.
I would think that the people that started Amazon either originally started using the word Amazon sort of informally without having done a trademark search, and then when it takes off, they end up doing the trademark search.
Now, in that particular case, before they went live, they probably had 4 or 5 trademark searches done. And this is
before they went live with the original Amazon website way back in the 90s.
Yes.
Okay. And
And
realistically, would they have changed it if they had known about the Amazon bookstore?
I'm sure they would.
I figured they just would have planned on the cost, wouldn't they?
I think that's right. But one thing that illustrates, though, is that no matter how thorough the search, you're looking for something you hope you don't find. And there's no guarantee that you're always going to find it. And I think now, with how thorough those databases are, is any business that's licensed anywhere, you're going to find it. But back when they launched, I don't think they had those databases available.
Got it.
Okay, any questions on that? Because this is a big thing. When you're talking about doing what you're doing, starting up businesses, you have to have clearance on those company names. And by the way, even if you have a corporate name, and you can get, I mean, I can file articles of incorporation in California for a particular corporation name. And the Secretary of State of California very well might issue that corporate name to me. But that does not mean, or it's not insulation from being sued for trademark infringement. There's lots of people out there that have corporate names, and then they start using them and find out that that name was not clear. Okay, so any questions on that? We're at 15 more minutes?
You got about 15 more minutes to go.
Yes.
I have one. So let's just say like you have a product, or like say like it's a drink or something like that. So would you have to get it a patent for its name and the recipe?
No, not necessarily. You don't have to have patent for something like that. And for a recipe, anything that, for recipes, there are a few things that are patented on the recipe. Most things are not. And let me get in the patents and I'll tell you why that is. But for the trademark, yes, you want to make sure that you've got clearance on that name before you do anything that costs dollars. Okay, so I want to get back to
we just click down
Yeah,
here.
All right. Good. Okay. Okay, so,
Is this where we were?
yep.
Okay.
Okay, so this is a lot of things that I'm going to let you just go through. I find some of these things really interesting. They're just interesting trademarks. Amazon.com, the one that's interesting about that is the A to Z, that arrow under there adds a lot to that trademark. This one, Carrefour, what's hidden in there is there's a C hidden in there.
Oh, yeah, there is.
Yeah, yeah.
I never noticed that before.
Yeah, Goodwill, that's the G that is that there, that's actually the smiling face. That's a really interesting case between North Face and South Bud. But again, okay, so I want to get to this because this is a lot to cover. Basic types of patents. What everybody thinks of when they're talking about patents is utility patents. That's where the money is. Well, let me back up. Plant patents in Kern County are extremely valuable because grape varieties that's probably the biggest thing in Kern County is the patent protection for various grape varieties. And I just got done with multi-million-dollar litigation over a plant patent on grapes. They are very valuable. But ordinarily, when we're talking about patents, when people say you have a patent on that, they're referring to utility patents. Anybody here watch Shark Tank? You'll notice on there very frequently they're asked, do they have a patent on something? Okay, it gives you the right to exclude others from making, using, offering for sale, selling, and importing a claimed invention. Okay, and it does not necessarily give you the right to make it, believe it or not. Okay, term of protection is 20 years from the effective filing date for utility patents. Okay, I'm going to go over this one briefly. In order to get a patent, it has to fit one of the statutory classes. It has to be useful. That's easy. The only things that are really not deemed useful are perpetual motion machines because they violate the laws of thermodynamics, so they don't exist. They must be novel. Novelty means all the elements of the claimed invention cannot be found in a single other known device, and they have to be non-obvious to someone skilled in the art of the invention. And I'm going to go over those a little bit. Okay, so patent searches. The reason you do a patent search, there's two different issues that are involved. Number one is patentability. Can you get a patent? And then secondly, if you make, sell, use that product, are you going to be infringing someone else's product? Or pardon me, someone else's patent? Okay. They're two totally separate analyses. As I said, you can be sued for patent infringement even if you have a patent on something. To give you an example, I come out with a widget, and it's an improved widget, and it has elements A plus B plus C plus D. Okay, that's what I'm claiming. And say there's a patent out there for the original widget that has elements A plus B plus C. Well, because each and every element of that widget is found in my client's widget, they're infringing, okay? And I'm going to give you an example of this in just a bit. I'm going to move fast here. Okay, search methodologies. We're going to go back to this. Okay, so conveniently, you do patent searches on the same uspto.gov website. And we'll do searches here. You can also there's also Google Patents. You can search there. I'm more familiar with the search engine for USPTO, but you can do it both ways. You can search both patents themselves, or you can do published patent applications. Either one of those can prevent you from being able to get a patent. Okay, so I'm going to run here an advanced search. By the way, I've got everything that's in this handout here. The patent I'm going to be referring to is right here, all right? And so say I have a client who has a check valve, and so I'm going to do a keyword search in here. And where I like to search, there are a couple places. I'm using a field search for title. I'm going to say check valve. It's got to be in quotes, and then using and. Then I'm going to use this field, which is abstract. The abstract is a pretty good place to look for patents because you're looking within the very brief description of what that thing is, okay? And so I'm going to say flapper and abstract port, and we'll see what that gives me. Okay, so this has given me 9 patents that are out there that have those various terms in them, and having that title and that particular words in the abstract. Okay, I think this is the one I want. This ever pulls up. Okay, that's not the one I wanted. Look at the number. 49. Okay, this is the one I wanted here.
Do you want to sit?
Yeah, I'm
You
good.
okay on your knees?
Yeah, I'm fine. So Google Patents, the benefit of it has images, okay? Because with the USPTO void framed, you can get images, but you have to download an image browser to be able to see them. Now, so I find this patent, okay? There's certain things you need to take note from it. First of all, if you'll see here, those are all patents that were referenced by the patent office when they allowed that patent, or when they were determining whether or not it was patentable. So if I'm doing a patent search and I'm trying to determine whether or not something's patentable, I'm going to be interested not only in this particular patent, but I'm going to be interested in the other patents that he was relying on. The other thing is you'll see that there's a referenced by link. That will tell you every patent that came out afterwards that references this one. Okay? Now here are, and I'm going to pass these out because this is the particular patent that you're looking at here.
Thank you.
This is show and tell.
Okay. Oh, cool.
So what about like the name of the business? So, like what if we have the same, just the same as somebody else and then we get licensed?
If that business is doing pretty much the same thing, that's going to create a likelihood of confusion, and whoever was using it first is going to have priority. And so that's.
Is there a website where you can check?
Well, USPTO.gov is one way you can check. You know, and as in the Amazon case, you can search a lot, but you don't always find it. So you just have to be really careful. And the more that exposure you have, you all familiar with the term exposure? Exposure means how much do you stand to lose if you're wrong, okay? And so again, if you're ordering inventory worth $100,000, you've got a lot to lose if you're wrong. And so that's why I would go out in a case like that, and I would have a third-party search report done, which might cost $1,000, and then I get an opinion letter from counsel saying, okay, we think it's safe for you to use it.
Can I ask a question quick as well?
Absolutely.
That Tasty Freeze or whatever,
Frosty.
Frosty King.
Yeah.
Thank you. The Frosty King thing. Did you guys prevent the other group from using it in Florida?
No, we did.
So they were allowed, you had like, I assume the owner here had no plans to expand the franchise to Florida.
Well, I gotta be careful what I say because we're still.
Oh, okay, sorry, I was
we're-
just
we're-
curious.
We're still litigating with those
Uh-huh.
guys, but ultimately, we've beat them back big time. And who knows where it's gonna go from here.
Okay, interesting. Sorry to interrupt, go
Not a
ahead.
problem. Okay, so you've got a patent there. That patent is on this check valve, okay? This is a Jandy check valve. And, I mean, to the extent that these things can excite people, this is a great invention, okay? This is used primarily in jacuzzis. The thing that is great about this particular invention is, see this cover here? Everybody know what a check valve is? It only allows flow in one direction, stops flow in the other direction. The way it does that is with a flapper. So there's this flapper in there that's spring loaded, okay? If, in this particular valve, if the seals on that flapper fail, you can fix it by just popping all those screws, pulling the cover off, and replacing the seals, okay? It used to be, if you had one of these things fail, you had to actually go in and cut the valve body out. A very expensive repair. So really great invention. And they get it patented. Okay, so, and this is the patent on that. If you go to, and patent attorneys always look to see the claims of the patent. You've got to be able to see here. Okay, if you go to, you see that they have columns, numbers at the top. If you go to column 8, which is on about the third to the last page, you'll see something that says what his claimed is. Everybody see that?
Mm-hmm.
That is the most important part of the patent. That is the legal definition of the invention. If the infringing device or the purportedly infringing device doesn't fall within that description, it's not infringing, okay? And so you'll notice, okay, there's claim 1, it has a valve comprising. Then claim 2, you'll see the valve of claim 1. That's shorthand for saying, take everything in claim 1 and add this. And what that means is that claim 2 is narrower than claim 1. In order for this device to infringe, it has to infringe one of the independent claims. It cannot infringe a dependent claim without infringing an independent claim. Okay? There are a number of independent claims in this thing. And so my client makes this valve, okay? And they're getting ready to go to a trade show. They are selling lots of these valves. And they get a demand letter from Jandy, like this Friday before they're going off to this show, saying, hey, you're infringing this patent. Okay? And so they in a panic, they call me and say, okay, what do we do? And I said, well, I'll find the patent. I want you to send me your valve, send me their valve. They did that. That's why I've got this, okay? So they send it to me, and keep in mind, in order to infringe, each and every element of that claim has to be found in this device. So if you read this claim, it will say, cover having a flapper assembly pivotably attached thereto, said cover being removably attachable to said housing in a plurality of orientations to selectively orient said flapper assembly adjacent any of one said ports. What that means is, on this particular valve, you can put that flapper, you can rotate it, and it's right now it's adjacent to that port. You can rotate it, and it can be adjacent to that port. Every independent claim of this patent has that limitation. So I get this thing, and you can't see it, but this is a molded top. That flapper can only be mounted one way. It cannot be rotated to go the other way. I photographed that, sent it to the attorney for Jandy, and said, we're not infringing. This is the first time this has happened. He wrote back and said, you're right. And so,
Oh, wow.
yeah.
That's surprisingly easy.
Yeah, well, we had threatened to sue him, said if you go out and tell anybody we're infringing, you can expect to be sued for tortious interference. So we gave them some.
They backed off.
Yeah, they backed off. So the importance of that is that really it's one of the best examples I've seen for patent infringement. I guess we gotta wrap this up.
Yeah.
One final thing on this, because I think it's such a great example. You might ask yourself, why did these guys write this claim this way? Well, I think it's probably because they were forced to do it by the patent office. In order to get the patent, they probably had to add that limitation to do that in order to get a patent. So,
Did you have other handouts there too?
yep, I've got my entire
The presentation?
presentation is here.
Let's hand out those two before people leave. And it's uspto.gov.
uspto.gov.
So I'm going to announce to you guys before you leave, I want you to visit between now and Thursday. We're going to do an exercise on Thursday to do patent and trademark searches. So I want you to think of a device, a new kind of device, or a new name for a company, or a name for a product. I want you to go to USPTO, go to either the trademark database or the copyright, or the trademark database or the patent database, and do a search. See what you come up with. We're going to talk about it in class. Okay? USPTO.gov. Sorry, go ahead.
Any questions? I've tried to cram a lot in there, so I won't be one.
Make sure you guys get a copy of this handout too before you go, and I'll see you on Thursday. Thank you, Jim. No, this is fine. This is fine. It's totally fine.
Hi.
Hello.
Beth Bywaters. I teach in the next class.
Oh, hi,
and
Beth. How are you?
And I just want to get set up.
Yeah, no
so
problem.
we're ready.
We'll get out of your hair here.
Yeah, here we are. Thank you.
So you need your drive bag.
Thank you.
There's the drive.